Hi guys, this is Sharifa Tharp with ST Law Office. Today I'm going to take a minute to talk to you about a particular issue that may be affecting you. So I want to talk about taxation of non-resident aliens. So I'm going to give you a little US taxation 101. So there are three categories of individuals that the United States seek to tax. There's first the US citizen, then there's the resident alien for taxation purposes, and then there's the non-resident alien for taxation purposes. So the US citizen, of course, is the person that was born or naturalized here and is a US citizen. So they either have a naturalization certificate showing that they're a US citizen or a birth certificate. Then there is the resident alien, which typically is the individual such as the permanent resident or green card holder. The resident alien is usually somebody the non-resident alien is the individual who is here temporarily, for example, such as, somebody on a student visa or temporary employment-based visa. Now, the first two categories, the US citizen and the resident alien, they are taxed on their worldwide income, which means that no matter where they are in the world, they're going to have to pay taxes on that income. So if they have a business in, say, Jamaica or Barbados or Brazil, generally speaking, unless an exception applies, they will need to report that income and pay the taxes on it. Now, the non-resident alien is different in that they only pay taxes on their US source income. So they're in the United States, if they run a business in the United States. So for example, if you're on an E-visa, E1 or 2 visa, you're running a business in the United States, or if you're a student here on a student visa in the United States, you would only pay your income on the money coming in from your business being run in the United States or from your employer who is paying you in the United States. Okay. Under rare circumstances, the water does get murky where the IRS may look at an individual and they cannot tell whether they are a resident alien for taxation purposes or a non-resident alien. And this is where they apply something called the substantial presence test. And it's basically a test that looks at the amount of time that the individual has spent within the United States to determine whether they should not be categorized as a non-resident alien, but instead should be categorized as a resident alien. In cases like that, then it's also very important to look at whether there are treaties that apply to help to reduce any kind of tax liability that may be imposed on an individual who falls within the resident alien category. So it's very important to sit down and consider these factors. Consider where you are, how long you are in the United States for, what kind of businesses you run, where are these businesses, who are they trading in, what kind of products are they trading in. These are all important factors in determining whether how your income should be categorized and how it should be taxed. This is why it's so important to consult a tax attorney to help you with your immigration tax planning, right? Because it could mean the difference between a smooth tax process or a complicated one. All right. So if you are having any kind of tax issues, you have tax questions, it's always important to come with the tax questions before the IRS has those questions for you. So if you have any questions about your particular situation, don't hesitate to call me at 561-405-4889. Let's go through it together in a consultation and come up with a plan that's right for you. All right? Have a good one, guys. Bye.